As already said to you, worship, we have two witnesses that's going to come and testify, that's going to identify the scene and the contents thereof. The contents of the video and what is being depicted there. Consequently, no trial within a trial should be held on the question of admissibility, as the defense will, apart from contesting this evidence by cross-examination, not be entitled to lead any evidence on this issue at this stage. The defense can canvass the matter fully when it presents its case. It makes perfectly sense. If I can go further, that in the instant case I expressed observations on the calling of Mr. Ackerman. Mr. Ackerman was a defense witness that was called within a trial. So the judge acknowledged that he erred in allowing Mr. Ackerman, but it did not change anything, whether he was called or not called. By defense, but in turn, out of turn at this stage, I allowed this procedure as it was also followed in State versus Regoban Supra to enable the defense to present its case on admissibility fully. The above approach does not mean that sight is lost of the dangers inherent in tape recordings. The judge acknowledged that. All these dangers have to be fully weighed when the question considered at the end of the case, whether the state that closed its case on the tape recorder are reliable. The decision will be reached on all the evidence that's available, which include that of the accused, should they give evidence. It's only then will the court know which portions of the tape recordings are disputed. Whereas at present, the defense is merely indulging in shadow boxing. I can go on and on about the number of cases. There's also a case of Harvey versus Nolan and others. It's 2016 in brackets 2 SA 436. It's an Eastern Cape decision. It's exactly the same principle. Judge Plaskett was the judge here. It was a judgment that was delivered right here in the Eastern Cape and has been reported. I have a copy of the judgment which I wish to hand in to the court for the ease of reference. Exactly the same principle, whether it was relevant. So I see my learned colleagues also touch on the section 15 of the Electronic and Communications Act, Transactions Act. This also provides the court with another option of just looking at the evidence because the video is real, it says can be handed in terms of this particular section. There's also another section which the court can hand it into, consider section 3(1) of the Criminal Law Amendment Act under the hearsay evidence, because there is a witness that can identify the contents thereof. And the court, it's my submission that it is in public interest. I can give the court a number of cases, except for the one that was quoted, that was so heavily criticized for the lack of logic in that particular decision. It was already in the Eastern Cape State versus Mdntv. Also in 1986, there was these two decisions that was taken. One is the Transvaal decision from Govan that was quoted by my learned friend. Then there was the one of State versus Mpumalanga, the one that's a case that emanated from Kwanabufe in Yehudah, where the Judge Mullins already decided at that stage that this is real evidence. In that particular case, the witness that made the recording was overseas. He didn't even testify. He sent it over to South Africa. They didn't even know who he was. The decision already was taken then. It's an issue of relevance. And the authenticity does not play a role when it comes to real evidence. We refer the court to Mahmoud versus Janssen van Rensburg. It's 1993, volume 1. SACR, page 67. It's an appellate division. And it goes to page 78. H2I, the state proof common purpose by the aid of video footage from a video surveillance camera. In all these decisions, State versus Fury has already been cited by my learned colleague. In People versus Dodgett, DOGGET. State versus Narayan, Naryan. It's 1998, volume 2, SACR 345. It's a Western Cape decision where the prosecution proved that the accused had the necessary intent by the aid of footage from a police surveillance camera in circumstances where an underthreat police operation was conducted. Here's why I can refer the court in State versus Dube. Same decision. It's a 2000 in brackets 2 SACR 583. It's an Natal decision. State versus Udugo. ODUGO. 2001 in brackets 1 SACR 560. It's also a Western Cape decision. In State versus Smith, also same decision. State versus Malay. Smith is 2002 in brackets 1 SACR 188. Transvaal decision. State versus Malay. I can state versus NEL, MEC for Health, Mpumalanga versus MNET. This was a video that was used to show in a civil suit by an undercover video footage to show how nurses in a hospital in Mpumalanga mistreated the patients who received abortions. In Holthausen, 1984, Volume 2, brackets 2, SA 852, it's a appellate decision. The court held that the type transcript of a tape recording is admissible as evidence of an intention to commit a crime. In all these cases, State in Newbold 1990, in brackets 4, SA 217, it's also a decision by the appellate division, where the court admitted the tape recording planted on an intrepid in an covert operation to obtain evidence in an illicit diamond buying deal. And last one, it's State versus Ndlongwa. It's a 2010, in brackets 2, SACR 419 SCA, where the court admitted video footage from surveillance cameras installed at the bank where the robbery took place. All these decisions already in 1986, from 1986 up to onwards, have already confirmed that documentary evidence is indeed real evidence, and that the normal rules does not apply. The only thing that the court have to look at is whether it's relevant, and that's it. And that the trial within a trial, it's really not the way to go. It's not a matter of authenticity. That's my submission. Thank you.
Yes, Worship. Firstly, our learned friend craftily utilizes the words that the two witnesses were present on the scene. So that doesn't resolve any of the issues. And I will explain to Worship exactly why. Worship, the debate between these two authorities is fully dealt with in the authority of the book by Hoffman and Zephyr that pages 705 to 709. Each and every one of the cases, most of the cases referred to on my left hand or referred to there in the Islands decision. And there's a comparative analysis there, Worship, between these two decisions. So my left hand firstly argues to your Worship that you cannot rely on such an old case as 1986-4, and then in the same breath relies on the very same 1986-4. It's just one of those anomalies in our law, your Worship. They both are from 1986 volume 4. So, Your Worship, the learner was this in photographs, forms, videos, forms, and sound recordings, which begins at page 704, deal with this very, very issue, Worship, from page 705 to 709. Your Worship, here we're dealing with authoritative authors who studied this debate and devoted formal time to it, and any of us, for Your Worship, with respect. There they say, Your Worship, that there is this distinction and different approach to the law between the Baleka decision and the Rambabin decision, and they refer back to the Rambabin decision at page 705, where it says it is not objectionable to ask witness whether he recognizes a scene or a person in photograph, even if he did not take the photograph, or was present when it was taken, or even if the origin of the photograph is unknown. But if the witness said he did not recognize any person or scene, the photograph would not be admissible in the absence of proof that it was what it purported to be. The case of R versus W establishes that photographs and films must be identified as true representations of the objects and persons that they purport to represent before they can be said to be real evidence. Objects do not prove themselves any more than documents do. And that's using the example, the illustration that I showed you worship to. The learned authors continue. The learned judge present statements that in italicized in this book to stress something that is of crucial importance. As we have seen, a document has to be proved to be authentic before it is received in evidence. So must the photograph according to R versus W. By apparatus reasoning must the sound recording or a videotape, with or without an oral component, be proved to be a true representation before it can be admitted. Or does lack of authenticity merely affect the weight that has to be attached to such evidence? Divergent answers were given to this question in a number of cases decided by courts in 1986. The Supreme Court of Glick has yet to give a definitive answer, as our learned friend of Q number 2 stated. Says, the approach of Mdntv, State versus Rangarbin and others gives with respect the best protection against the abuse of forms, videos, tapes and sound recordings. So here are the authors who studied this aspect of the law and have conducted a comparative analysis of these two cases, saying that the Rangarbin approach is the best protection against the abuse of forms, video, tapes and sound recordings. And I want to go further, Your Worship, and say this is the clearest example. I can tell Your Worship, I have the photographer, I have the person who made that video. We put him we challenged him. Instead, he tells Your Worship very craftily, they were present on the scene. He doesn't say, Your Worship, they never witnessed the incident in question because that's the case. So I can be present in the court building, not knowing what's going on in this court. Does that qualify, Your Worship, to come and give evidence of what occurred in this actual room? With respect, not. And I'm going to read to Your Worship the relevant parts in the next 4 pages from 705 to 709. And say, his Lordship's view starts with the notorious fact that one is dealing with evidential material says all the trappings and suits of reality, but which is at the same time both peculiarly fallible and open to manipulation, difficult to detect. Wide use of video forms in the entertainment industry has resulted in the techniques of illusion and deception being brought to powerful perfection. And the illusion is so much part of our lives that we tend not to notice it and indeed to accept it as if it were reality. And that's what I'm asking Your Worship to guard against. My learned friend has no defense to that. Now they continue. It says it is not enough merely to ask. As abuse in fact happened in the case that has been tried, this is precisely because in many cases simply does not know. That in a nutshell is the rationale for the approach laid down in State versus Rangarbin and others, deciding whether certain audio and visual tape recordings were admissible. Previous South African cases offered little assistance. In State versus VEII, the appellate division had merely held that where the accuracy of the tape recording has not been established, it is not safe to rely on it without corroboration. The majority of the court in R versus Berman held that a dictaphone recording was inadmissible possibly because it did not adequately correspond to certain copies and transcripts. In S versus P, it was made clear that there must be proof that the evidence has to be what it purports to be, that there must be evidence argument establishing its accuracy. These decisions he submitted do not stand in the way of Mdntv's conclusion as how the dangers inherent in evidence of this kind have to be met. The learned judge present followed what had been laid down in State versus Singh and another, which was binding on him, which was indistinguishable in principle. It laid down as regards tape recordings that A, it has to be established that the recordings are original recordings and that if sufficient doubt is raised by the defense that they are not original, the court must reject them. And B, from the evidence as a whole, there exists a reasonable possibility of interference, the recording is inadmissible. Mdntv concluded that the rule laid down in State versus Singh was not an exhaustive set of requirements for admissibility for recordings that are admissible must be proved according to Rangarbin's case that they, A, all the original recordings and B, that on the evidence as a whole there exists no reasonable possibility of some interference. In a criminal case, the State must also prove that the tape recordings do relate to the occasion to which it is alleged to relate, and that they are faithful and prove the identity of the speaker. There must be a witness to the event reportedly recorded on the tape to testify that it accurately portrays that event. Now, I know if it says they were present at the scene, it doesn't say they witnessed the scene. And that's the distinction, that's the dangerous distinction that is incapable of curing on the facts there's none to us from the pulpit, Your Worship. They then do a distinction between the type requisites to admissibility precisely because having them is the best way of guarding against the grave dangers inherent in this kind of evidence. They then go into the case of the game, and they say at the bottom of page 707, it is submitted that in both instances they should not be treated differently, both the reality and authenticity should be proved as requisites of admissibility. They then quote the cases that Van Dijk had reference to, the older cases, and they then go through what should happen. And then page 709, and this is where the conclusion comes, Your Worship. After going through and I've read, Your Worship, the 7 requirements from the government's decision, the last paragraph before this reference to the Fury decision, Your Worship, reads as follows. If the learned judge present is correct in his view that authenticity goes to the admissibility of evidence of this kind, and in brackets they say it is respectfully submitted that he is correct. Factors 1 to 6 constitute useful if not exhaustive criteria for admissibility. Factor 7, of course, is subsumed by law relating to admissions and confessions and criminal proceedings. If not, they are valuable criteria for the assessment of weight. And then there is reference to the authority that Your Worship referred to State versus Fury, and as I said, and I'm going to repeat myself, unfortunately, Your Worship, they say, in State versus Fury, it was held that a photograph of a moving motor vehicle by so-called speed camera is admissible without the witness testifying that it was the correct image because the reliability of the camera is not an issue. There's no dispute that it had been properly set up and operated. And that's the distinguishing factor, Your Worship. That here it's not the case. In fact, Your Worship, just to do it, page 707, they refer to one of the co-authors erroneously arguing that the decision of Glick was correct. And this is at 707, says that they argued erroneously by a co-author of this book that this approach shows a commendable lack of objectivity and makes more sense to receive a copy and evaluate its weight in the light of all evidence. The rhetorical question was, why should the court be precluded from considering its weight because of a rigid exclusionary rule? This being our submission is misconceived. And the fact that it is real evidence does not mean that it proves itself. And Mdntv has shown lucidly with great force in the Darwin's case that there should be prerequisites to admissibility precisely because having them is the best way of avoiding against the great danger inherent in this kind of evidence. So let's try and pass to the facts here, Your Worship, and not lead to academic or to regional approach. If, for instance, Your Worship, somebody claims that here's a video and plays it to the court, without being able to say, this is the person who made this video and can attest to its reliability, in essence, Your Worship, it would be misleading this court, is the argument that we have. Absent a person who says, I am the cameraman, this is how I set up the camera, this is what I personally filmed, and that's important, but I can film up, I can set it up, I can leave. But if I never filmed it, it doesn't say anything about the reliability of that which is captured in the video footage. My learned friend needs, the state needs, in this instance, somebody says, I sat there, I filmed this, and this is what I saw and filmed at the same time. It's a contemporaneous recorder of what I saw. Absent that, it's unreliable, and he cannot, with respect, satisfy that requirement here. And he knows it, and that's the problem that he has here. Therefore, we object to it.
Just on 2 points, which I didn't say the 1986 case from Google is irrelevant. I didn't say that. I said it was heavily criticized. Just want to rectify that submission made by counsel for case number 1. Secondly, also there is the case that I've quoted, Madrongwa 2010 is number 2, in volume 2, SACR 419 SEA. It's a Supreme Court of Appeal decision. It is a decision in this regard. Thank you. there is decision regarding that. I think my learned colleague said there's no, so for the Supreme Court of Appeal have not really pronounced it. There is a case. Thank you. That's it.
Mostly then your two requirements for the trial within the trial is whether the evidence will be detrimental to the administration of justice, if it will render the trial unfair, and whether if there was an infringement of any right as contained in the Constitution. So what is your application specifically based on?
That would go back to the Mardi decision, Worship, in the cell. And yes, Worship, to allow evidence of this nature would be detrimental to the trial within the administration of justice into disrespect and be prejudicial to the accused because my learned friend cannot prove the reliability of the evidence. So one cannot say it's relevant that it's unreliable. One must first prove it's reliable and then one can be into the issue of relevance.
Thank you. So how infringement is being brought to
there is the court has a duty to ensure there's no infringement. If the court were to sit back and allow all types of evidence to be admitted without ensuring that the evidence is reliable, it would result in unfair trial to the accused, clearly prejudicing.
Thank you. Anything you wish to add to that, please?
From our point of view, we're looking at this as a matter of authenticity. There's a very authenticity and cannot be the originality of it be proved by the state. Why I requested a child in the trial already is because often it's record in dealing with the proof of such evidence suggests that it be done within a trial, so that if I could just get you the issue. But I suggest that the matter be decided in a trial within a trial. It's much safer to do it that way, so that inadmissible evidence is not led in the main trial. And then, of course, my lady comes to the decision that it's not only authentic, it's the original and it's admissible. if that is the result of the trial within the trial. It's just a safeguard to mean that if we do it that way, it's much safer than doing it in the main trial.
Thank you. Nothing else?
My submission remains the contrary.
Wonderful that I've been informed prior, so you have given me a lot to look at and to read. I'd like to be optimistic and say after the lunch agenda, but I cannot be 100% sure. There's a lot quoted by the state defense for accused 1 as well as accused 2. To the learned authors, I need to satisfy myself that agreement. So there's a lot. My second problem, delay that I foresee if we don't utilize as much court hours is, let me just confirm, Sergeant, in our load is our go-to guy for load shedding schedules. Can you ask, is there any load shedding tomorrow or are we spared? 9 to 12. So that's ISCO. 9 to 12 load shedding. That means ports do not function. It comes to a standstill. Recording machines can't be switched on. Thereafter, it takes 30 minutes for the server to kick in. Eats up our court time. We work 3 tea before court, lunch time to catch up. So at this stage, I think I will leave you to the decision if you want to risk and take the chance and wait for me possibly if I'm ready, or we resume in at this stage until tomorrow, 12:15. Do you want a few minutes to discuss and then just call me?
Bishop, speaking for myself, I don't want to put your worship under any more pressure. The issue of the trial and the trial is on pages 506 to 513.
Oh, you still have
But just on the issue of the trial and the trial. Worship, unfortunately, worship, we cannot expressively it's up to worship and worship will be ready. If it's this afternoon or tomorrow, we're time in the worship center district. With respect, and I know you have other pressing issues to deal with as well, and other aspects to be taken into account and the lack of hours to be in the worship center district.
For us to utilize, I don't have a list of any witnesses or possible witnesses. May I inquire, is there any other witnesses available which we can proceed with today, which is not pertaining to the video or the footage or the clip?
No, Your Worship. Everything is about, all the witnesses are regarding this.
In your hands, I think it would be safe if we just continue tomorrow.
Yes.
Already I've been referring to an article, Admissibility of Electronic Evidence in Criminal Proceedings. My hand is up to you, it's just that
Any aid is welcome.
it's just an aid. So if I may ask my ballistic expert some work for it. Thank you.